So what I'm going to do today is I'm going to categorize some forms of inappropriate use of social media, because that might seem very obvious to you, but it's actually useful just to start at what lawyers like to call the starting point. And then I'm going to give you some ideas about rules and about guidance, and I'm going to pepper in some examples from other associations, some of whom might be here. Then I'm going to talk very quickly about defamation, because if you're involved in social media in any leadership way, then I think knowing something about defamation is very, very important. And finally, I'm going to give you some takeaway thoughts before just going on to opening myself up to questions. So let's just talk about what is inappropriate use. So I've categorized it in three ways. I've called it clearly inappropriate, less clearly inappropriate, and then asked a question, is there any impropriety at all? Now, when we are talking about clearly inappropriate, abuse, sexual, racist, grossly offensive material, it's actually going to be pretty rare, unless you're very unlucky, to have what we call the paradigm case, the case which is just black and white, cut and dried, where somebody has directly been sexual, sexist, racist, or offensive. Because clearly the answer to that is pretty simple, that you have, as Chris said, you have a word with that person, you exclude them, you do whatever steps you need to take technically to stop them from acting again, and then take any action against them in their role as a member. But as I say, I think you're going to be lucky/unlucky to get a case like that. I think what is more likely to occur is having comments or interaction which is less clearly inappropriate. And so I've started, I've put down a couple of bullet points, and these are really to get you thinking. What about comments about work and about recipients of services? What if one of Charlotte's members says that big companies always want you to fiddle the figures? As an accountant, I don't like doing that. What about that sort of content? What if that person's name is on there? What if you go to their LinkedIn profile and it's quite clear which audits they've done in the past 6 months, and it's pretty clear they're talking about a big soft drinks company, for example? How does that affect you? Is that inappropriate, or is that whistleblowing? What about posting of views? What about after Brussels, if somebody says, in solidarity with the other members of our RICS, these terrorists are terrible people, and then maybe goes on to say something a bit more controversial? What about criticism of the profession? What about somebody saying that actually I don't think this organisation should be run this way. We're not stopping our members doing things which are wrong. Is that inappropriate, or again, is that whistleblowing? I'm not going to give you any answers at the moment. I'm just going to put those thoughts out. Then there are those, that category where I really think you've got to ask yourself, is there any impropriety at all? And I think the answer will come from looking at the context of the social media that your organisation is engaging in. So the endorsement of products, for example. So it could be that if you are in a health-related profession, that actually the endorsement of products without, in any shape or form, is completely inappropriate when you're using your professional designation. It could be that professional comment is not appropriate for as I say, the freight train sort of nature of social media. Again, no clear answers, but just something to think about. So let's just start thinking, with those categories in mind, let's just start thinking about rules. And I've set out three, again, categories of the types of behaviour, the types of conduct that you might want to have rules apply to. So we're not talking about the rules themselves yet, we're talking about the types of conduct. Expression generally, the use of social media specifically, and conduct generally. So what are the differences between that? A rule that targets conduct generally, or a rule that targets all three of those categories, would be something like that you must not be offensive towards other members. Now that doesn't matter whether that rule will apply if you do it over the coffee break during a professional conference, whether you do it using social media, or whether you do it through your website or through a letter or whatever. So all three will be captured. There are forms of expression which are social media specific. I'm not going to think about them here, and you're probably much better qualified to think about those. The point I'm trying to make is to get those categories into your mind. And the reason for getting those categories into your mind is then you can start thinking about whether you need specific rules to cover social media. Again, this is something that I think the previous speakers touched upon. Are there particular policies that you are going to need with regard to social media, or do you actually have conduct rules, and we're going to look at those in a bit later, that actually cover social media quite adequately and you don't need anything specific? I suspect that the answer is going to be somewhere in the middle or a mixture of the two. There are some particular technical issues that I've noticed as a lawyer that arise through the use of social media. Unlike your normal sort of HR case where somebody has been abusive to someone else, well, hopefully it's not normal, but you know, the case which again is cut and dried, somebody being directly abusive to someone else in the workplace, quite a lot of the mischiefs that occur via social media are not direct comment or direct speech by an individual, but they're actually to do with retweets or the joining of groups. And something that I've come across in my practice when advising professional associations and other membership organisations is that they've said to me that, look, this person, if you go onto their Facebook page, has shared something which is completely offensive, or has liked something which is completely offensive. And you look at the post that you're talking about, and it's horrible, it's terrible. But you're saying that I say to my clients that, are you seriously saying that this person has said this because they've simply clicked a like button? Now, it could be, again, I don't really have the answer, because I think, and the reason is that I'm not just being lawyerly and getting out of giving a clear answer, because I think it all depends on the context, and very importantly, it depends on the rules that you have put in place. There are some other issues that I've noticed. Social media content is generally done in private. That's one of the features of it. It's done, as somebody said before, you can do it from home. You can generate content from home. You can generate content, or you do generate content at your desktop if you're doing it in a professional context, somewhere which even in our sort of open plan days these days is private and is personal to you. Are we sure that that content has emanated from that person? And also, what responsibilities do we say that a holder of a Facebook page or a Twitter account or a website has? I think it's slightly clearer in the case of a website, because there are technical barriers generally, or you ought to have technical barriers to stop people altering your website. But where you've got a website which encourages user content or user interaction, then what control do you have over it? We're going to come back to that point in a bit, because we're going to talk about defamation. So let's move on to another issue, which is about what I call beyond the password. So two questions there, again, no answers. You notice a theme here. Is it legitimate to go into somebody's private account to establish wrongdoing? And a related question, what can be considered to be private on the internet? Well, let me, actually, I'm going to break with tradition and I'm going to provide you with an answer. So let me answer the second point first. What can be considered to be private on the internet? Well, I think the strict answer to that is that there are some things which I think you have a reasonable expectation to have kept private. If you have sent an email to someone in a closed network, then I think you have a reasonable expectation for that to be kept private. But notice that I use this sort of slightly odd formulation if you've used an email to someone in a closed network. As we know, most emails aren't in closed networks, and almost all professional emails, you can't expect them to be kept within a closed, well, they're not in a closed network, and you almost certainly can't expect them to be restricted to the person that has received them. you may have received been unfortunate enough to receive an email from a law firm, and it's not just law firms that do this, that have got essays written at the bottom of their emails, footers that go on for ages, saying about, if you're not the person that is supposed to have received this, then we'll clap irons on you and send you down to the Old Bailey. They are of limited use in limited circumstances. The fact is that if you send an email to someone denigrating someone else, you can't really expect it to stay private. There is a hope, there is an expectation, there's a trust in the other person, but all sorts of things can happen to make it go, if not viral, further than you would expect it to go. So let's just return, and sorry, so just to stay on that for a second, that is plus 10 when we are talking about social media. If you post something on your Facebook page, you have got security settings, which I think help in establishing the type of expectation that you had, and perhaps provide some sort of a defense if you are accused of spreading something perhaps wrongfully. But ultimately, Facebook is a public forum. The whole point is that it's supposed to allow for interaction with networks where you don't control the end of the network, the end of the line. You have friends of friends of friends, people that you've never met, people that you will never meet in your life. So I think sort of posting something on Facebook, however private you've kept it, there is still a danger. So to go on to how legitimate it is to go into someone's private account to establish wrongdoing, there are really two issues here. The first issue is a what I'd call a don't ask, don't tell policy. I don't think there are instances that I've heard of. I'm not an employment lawyer, but I've heard from my employment colleagues, particularly in the United States, where actually you're asked at job interviews for your passwords for social media, so that the employer can check what is in your social media accounts. Now, I don't think we've gone that far here. But if on a Google search of your name, and particularly if you've got a slightly unusual name spelt slightly unusually like mine, then you can pretty well much expect to have almost everything about you that's been put out on social media and otherwise come up pretty obviously, and particularly where you've posted something which you thought was private and has then been shared by people who are friends of friends of friends of friends. You very quickly start losing control of that. So to go back to the don't ask, don't tell point, it's all very well to say, look, unless I am aware of something, then I won't know. But how far does that go? Does that go to, but I will, knowing something includes Googling you, because that's something which is open to anyone to do. Does it also go to someone at work then saying, well, actually, I'm friends with this person on Facebook now that I've known them for 6 months, and they're posting stuff which is completely denigratory of the profession, of our members, of our organisation. What usage can you make of that? Well, I would suggest that you can't have an expectation of keeping things private on social media. That said, there are, it is all about expectation, and it is all about reasonable conduct. And I think that you can have rules, but I think that what you ought to do is have education, particularly for people like me, because I don't know how to keep things private, to be quite honest with you. That's why I don't post things which I don't want disseminated across the world onto social media. But just more generally, I think this is the freight train aspect of it, to sort of make people aware, even people who are very savvy and knowledgeable about the internet, well, not necessarily about the internet, that makes me sound like my grandmother, but about social media and about how things can get I think people are not aware, those people are not necessarily aware about how things can get out of control and how easy they can get out of control and how they can be affected and how they can then in turn affect their organisation, their employer, the profession that they're a member of. So let's look at some examples of policies. So the BMA really sort of emphasises a sort of ethical approach to the use of Facebook. It talks quite a lot about patient confidentiality. It talks about the sort of the duties between doctor and patient and the people that you come across in your medical professional life. It then talks about some privacy settings that you can set, and it encourages you not to befriend people or befriend patients on Facebook. It's very much quite a sort of educational approach, which really emphasises the sort of almost the morality of using social media. The NASWT, which is a teaching union, perhaps because of the types of issues that its members face, adopts a slightly different approach. It has got quite and you've got the links there, so you can have a look at these policies yourselves later. But it talks quite a lot about how to keep your post private. It's quite almost technical about keeping social media content private. But it also ends with some guidance, about some quite hard guidance about what will be considered acceptable and not acceptable if members are found disseminating particular views on social media. And then you've got the Nursing and Midwifery Council. And I particularly like this example because what the Nursing and Midwifery Council have done is they've separated their rules from their guidance, and then they have sort of sought to marry the two together. They've sought to explain, by reference to their rules, how your social media conduct can breach those rules and how to stay within the parameters of those rules. And I think that that's a really good model. So let's talk about some specific rules. I think you should, bearing in mind the categories of conduct that we talked about before, I think you should think about an all-encompassing bringing into disrepute provision. And you might have one of these already, in which case you should think about whether you should have guidance that marries that bringing into disrepute provision in line with social media usage trends. So a bringing into disrepute provision, for those of you that haven't come across one, is a simple rule that says that as a member of this organisation, you won't bring it into disrepute. That's it, full stop. And the beauty of something like that is that, as you can imagine, it covers a whole load of behaviour and conduct. You don't have to list it out at the time that you're drafting your rule book. But then I think you need to consider whether specific circumstances need to be dealt with. And I think perhaps this is more about the type of profession or the type of membership that you have, and also the type of platforms that you're using. So if you're using Yammer, for example, and that's it, that's the limit of your social media output, then obviously you are going to have very specific type of circumstances because everyone is going to be internal to your network or a member or an employee. If you're having, as I assume that most of you, including our ICS, will have a wider social media outlay, then you need to think about how to deal with other people that are interacting with you in your organisation. And then we've talked about guidance, and then actually just think about whether you need seminars as well. And I think that for some of you, this will be something which is just too much. For you, it's going to be something that actually we'd rather have, if we've got all our members in one room, we'd rather talk to them about things which are more relevant to their membership. But for some of you, for example, if you are running a teaching union, social media is a real and active threat to the interests of your members because so many pupils are on it, because lots of teachers are on it, and the interaction of those two things could potentially be dynamite. So just think about your membership and think about who they are and think about whether actually how far do you need to take some of these points away in terms of practical action. Is it simply looking at your rules, saying yes, they're fine? Is it actually going forward and getting some guidance out? And is it actually perhaps even going further than that and getting some seminars in place that talk about some of the issues that we've raised today? Some quick points about some risk areas. We have regular publications which are in print online. You need to check comments. There was some mention about pre-moderation and moderation. I agree that pre-moderation is probably not required, and I don't think it's required by the law, which is something that we'll talk about in a second when we talk about defamation. But just check comments, particularly when you've got something which you are sending out on a repeated basis, because I've seen examples where send or post is pressed on a regular basis for a weekly update or whatever, and just it's not monitored, or only certain parts of the reaction are monitored. We talked about user-generated content and being careful about that. Disciplinary employment disputes are probably outside of the scope of this conference, but it's just, again, something that's worth talking about, because particularly where you've got something like Yammer, where you're talking about a closed network within a particular workplace, albeit a workplace with many sites across the world, we might well come into HR issues and into employment disputes. If you are regulating professionals, then there might be disciplinary issues as well. Something that we haven't really talked about is the publishing of personal and confidential data without consent. And this is something that I think that everyone, and I'm not going to say very much about it other than to get you thinking about it, it's something that I think that everyone that's involved in putting anything on the internet, be it by way of your website or be it by way of social media, needs to be careful about. It's about sharing. You are holding lots of information about individuals, and if you share that inappropriately, then you are vulnerable and you are at risk. Let's talk a bit quickly about defamation, because defamation or libel law is a big topic. It's not something that we're going to be able to cover today, but I think it might be useful just to perhaps set out some of the basics and also perhaps blow away some of the myths around it. So there's a definition of defamation up there: a statement tending to lower someone in the estimation of reasonable thinking people generally, which sounds lovely in 19th century, probably because it is. But it actually says it does what it says on the tin there. It's pretty straightforward. That's what's defamatory. Your intention is irrelevant, so people saying, well, I didn't mean it that way, is not necessarily a defence. But you do have lots of lawyerly arguments about what the true meaning is of something. But forget about that for today. What the takeaway point is that intention about defamation is irrelevant. There's a bit about loss which I won't go into now. The bit that I want to really sort of bring to your attention is who can sue you for defamation, because what you will have heard of in the newspapers is, Elton John suing for defamation or Max Mosley suing for defamation. But what's really quite important to bear in mind is that companies can sue for defamation. These don't tend to be very well publicised in the papers or in the media generally, because they tend to be quite, frankly, boring cases. But they're about, whether somebody's sugar content is high or low in a particular type of product. But the outcome is worth millions, because if somebody has wrongly said that the content of a particular product is X when actually it's Y, and that company Z has therefore lost millions of pounds as a result of that statement, then you can see why defamation proceedings might be afoot. So it's just important to bear that in mind particularly when you're dealing with a membership who is employed by large organisations or deals with large or corporate organisations. Political parties, central or local government departments cannot be defamed, and I think that's important just as a general principle to remember, but also to remember that actually that may well trickle down if you are talking about comment which might be seen as whistleblowing. So you just need to keep that in mind. We've talked about user-generated content, And again, let me just touch on this monitored and moderated point. The law recognises that in today's world it is impossible or is far too stifling to have pre-moderated content. So content which you check or comments that you check before you allow them to go on. That completely cripples the model for social media. It's perfectly permissible to check content after the event, but ensure that you do. And also, the law is very sympathetic if you are open to hearing comment from others. So if I am commented about on your website, I get in touch. There's an easy way of getting in touch with the moderator to say, I think I've been defamed. You then take that post down immediately. You can conduct an inquiry about whether I have been defamed or not afterwards, but you do that, the law is going to look on you favourably. Very quickly, I'm going to talk about some defences, and I'm just going to talk about the first two, actually, because truth and honest opinion are a defence. Now, I know that I said that intention is not a defence, but honest opinion is different from having good intentions. Honest opinion is that you've come to a reasonable opinion about something. And again, you can spend hours and thousands upon thousands of pounds on lawyers discussing what opinion is reasonable. But the point is that you've got to have a good basis for an opinion. The law is not there to stifle the dissemination or the talking about of opinions. But the most important one is truth. Truth is a defence for defamation. If somebody says, well, I won't use myself as an example, but if somebody says about Max Mosley that he likes to go to prostitutes in Kensington and get tied up or whatever it was that he was doing, that bit is not defamatory, even though it tends for some people to lower their opinion of him. It's true. The bit that he won his defamation case on was that the Sun or the News of the World, whoever it was, said that he dressed up as a Nazi. And actually, if you look at the pictures very carefully, he's not dressed up as a Nazi. He is dressed up as a German soldier of some description, but he's not a Nazi. And on that, he won his defamation case. So with that negative example, I just want to show you that truth is actually very, very important. There's some takeaway tips. I've been given my 5-minute warning, so I'm not going to go through those in any detail. They're there for you to take away, and I'm going to be around over the lunch break for more private questions, if you have those, but at the moment I'm open up for public questions.
Fantastic. Thanks so much.